Hi, everyone, and welcome to the Licensing Jungle. I am Carmine Danisco, the moderator for this session. I have with me the host of the show, Jeffrey Mangus. And today on the Licensing Jungle, we have a intellectual property firm who has been around for a number of years. These guys are great. They're really inventor-centric. They really look to help out the inventors. We have J.D. Hoovener and Irene Solomon from Bold IT, I think, right? Bold IT?
IP, P's and Paul.
Bold IP. And we have them on. And Jeffrey, I'm going to hand the show over to you, and we'll just start asking a few questions and go through this. This is going to be a very interesting show. We're going to get a lot of people that are really interested in intellectual property questions.
Hello, this is Jeff Mangus, Product Coach USA, and I'm the host of the Licensing Jungle. Thanks so much for tuning in, guys. I really appreciate you being a part of it. Thanks, JD and Irene, for being here. And let's just jump right into it. So if you don't care, tell us about your firm and what you specialize in, of course, and kind of just tell us what's going on over there.
Absolutely. Thank you, Jeff. It's an opportunity. Thank you for this. Our firm, we do work with inventors, and with Bold IP, we found a way to deliver a boutique patent and IP suite to inventors of all walks. You name it, from garage inventor to Fortune 500 company. We're able to serve very efficiently and effectively, sort of in a one-on-one way, patent attorney to client, and do that by virtual representation. So 95+% of our representation is through clients over video chat, much like we're doing right now.
Wow, that's great.
Email, phone call. So we're able to deliver, instead of spending money on all that marble and brick and mortar, we convert that right to value for the client.
That's really good.
It's been fun growing the firm. We brought on Irene better part of a year ago. She's an IP licensing specialist. And, she's down in California. It's been wonderful having her on the team, work with kind of on the fun side of patenting. And once you have the IP assets and you want to try to help your clients get a license or sell, that's what she does. And so we do a lot of work on the front end, getting the best asset possible for our clients, and want to help them on the business side too.
That's great. That's great. I know I've worked with you and Irene, and you guys have been a pleasure to work with. I really just appreciate that. So let's just kind of go into it. A lot of our listeners might not understand, even though they're inventors, they might not understand the complete semantics of, how long is a patent, how some folks might not even understand how long is a provisional patent. You can talk a little bit about that, just kind of just some nuts and bolts on those kind of things, on how long a utility patent, the duration, those kind of things, if you don't care.
Absolutely. And patent law is one of those things that it does take some time. You've got to sit down and get into it if you want to learn about it. You can't just go, start Googling. It's one of those things you need to make sure you're getting good quality information, especially for those inventors that spend hours and weeks or months or years on their invention. Right. It's going to be worth a few hours to sit down and take in some good quality info. I do recommend going to our website, boldip.com. There's great information there. If you're going to do one thing, I'd recommend that you take a look at our book. Okay, it's right now for free. Bold Ideas: The Inventor's Guide to Patents. It's a 100-pager. It's a small booklet. It's readable. I boiled down the 40 or so most common questions I get, and I delivered answers here. This is just a great way for someone that's thinking about it or hasn't met with an attorney yet and wants some core information. That's what I recommend. To go to your question about the patent process, just really simply for us, we encourage a patentability search right up front. Yes, of course, it's the inventor's job, I think, to do their cursory diligence on their own, but hiring a professional to do a worldwide search for patent information, non-patent literature, to make sure that what you have is new is essential. And it's the backbone of the entire process. So once we get through a patentability search and we're through that wicket that, we think there's enough here to warrant moving forward, we do our work on application. And depending on the sophistication of the client, we'll recommend either a provisional or a non-provisional. Real high level, provisional protects the priority date. That's really what you're going after with the provisional. You get to file first, and that's what we're in now in that system since 2013 with the American Invents Act being issued, signed by Obama then. It is not a first to invent. So not so important anymore are those inventor notebooks. While they're good to keep for documenting, you're not going to be able to come in and say later that, hey, I invented this first. It's who files first. And so that's what a provisional does more than anything. It certainly helps you with not having to lock in your claims. You lock in claims at the non-provisional phase. And we can talk about some of those details later.
Right. Really good. That's great. That's great information. And a lot of folks don't even understand what you just said, but they do now. That's great. But you're right. It used to be a first to invent, and I'm still encourage students to use inventors notebooks and those kind of things. It's really still important, but again, it's first to file now, so it's first one to get there it's really important. And I love that. So just another question is something here. This is something that I've always wanted to ask a patent attorney, and you, honestly, I really wanted to shoot this one at you. And I think a lot of inventors coming in contact with who I come in contact with, there's a lot of fear out there, a lot of fear about losing their intellectual property and having to protect it. Now, again, without disclosing anything, how many times in your career have you actually had to protect someone's intellectual property? How many times has it happened?
You're talking about infringement situations?
Infringement situations, yes.
Yeah, I mean, it happens on, I would say, about half of every single client's case. So, I mean, I would say 20. And we've had the fortune to get enough of our patents issued and granted and moving along. Well, not all of them are actually businesses, ongoing concerns. Of those that are, I'd say half see an infringement issue. Okay, whether they're getting letters from people that saying, "Hey, look, you're whatever you're selling on the market is infringing our claims."
Wow.
Because they're out there creating and just being in that space, or they're proactively monitoring on their own behalf, or we're doing the monitoring for them, and we see a product or service out there that we think does read on the claims. So it is common, and we look for it. And for those clients that have hired us to do some of these brokering services we have, infringement is, people do think of it as sort of a, oh my gosh, how horrible. But it's actually a sign that people are using it and interested in the technology, and it makes it more valuable. So it's part of our analysis that we would send off to a broker or someone that could connect us with a licensee or buyer. They want to see infringement. So we want to actively look for that to get us in a better negotiating position.
I think a lot of the fear too, and you correct me if I'm wrong, is, from the inventors that I talk to a lot, they're just, I mean, again, I understand what you're saying about from business, a lot of businesses are looking, there's a lot of things going on, but I think a lot of inventors, independent inventors, are still afraid that some big company is going to steal their idea. Now, not saying it doesn't happen, but do you see that often, or do you see that not happening as much?
Well, so I mean, in the perfect world, it's kind of odd to think about it this way, but that if you actually get a patent on with a good set of claims on, let's say, a product, and an Amazon or Google or Microsoft or Facebook goes out and starts infringing clearly on your claims and kind of does the David versus Goliath thing and says, "Look, sue me." If they do that, I mean, that is a gold mine. If you can actually prove that, you've got a lot of options as the David, right? You can sell if you can sell your rights to another big guy, right? Who can then take on the Microsoft, the Google, the Facebook. You actually could hire an attorney like Bold IP, right? We could pursue a pre-litigation and seek settlement. If it's really that clear, we would do a validity opinion to make sure that those claims are indeed valid, that they would be upheld when the PTAB, Patent Trial and Appeal Board case were to be started, and then we would do an infringement opinion.
Okay.
And once those two things were done, I mean, that's kind of an odd touchdown, right? If a company that big is ignoring, even willfully infringing, they're in big trouble.
Right.
You've got rights and you have protection. You don't need to go through what you might think of as kind of as burdensome litigation. If you've got an attorney's opinion that's reputable, they will settle. Right.
Well, again, I'm glad you said that, because hopefully it'll make some listeners feel a little bit better about it, to know that the little guy can stand a chance if something happens. the big fear is, oh my gosh, they don't have enough money to protect themselves and go after the big guys. And in a lot of cases, that's true. But then again, what you're just saying is that if things are done right, then a little guy has a chance. And
Absolutely.
That's really great to know. I'm glad that he was able to talk about that. So just real quick, this may sound like a really funny question. Is there one particular, and Irene, jump in here too if you know of something here. Is there
Sure.
one particular, now without disclosing any names or anything, a particular horror story of someone who basically was had to fight against their intellectual property and a little guy? Let's talk. Do you know of anything like that in particular that because I think a lot of inventors are interested. Because this is one of the biggest topics they talk to me about is protecting and fear of losing and all this kind of thing. So.
Let's see. Irene, jump in, but I mean, some horror stories. Nothing comes to mind. I'm trying to think.
That's good.
Yeah.
Yeah, me either.
That's good. That's a good thing then.
I'd say that there is one case. I wouldn't say it's a horror story, but it's where this client came to us after they'd secured their patent rights.
Mm-hmm.
And they needed our help to revive the patent after it was granted, and so we are representing them on a case, and it's got we didn't write the claims, so we had to really look into it, and it's got some good coverage, and it's in the artificial intelligence space,
Okay.
bots, right, and the way that it's drafted is it's a method and process claim.
Mm-hmm. Yep.
And while we have strong suspicion that, for example, Microsoft and among many are likely infringing, it's extremely hard to pinpoint any actual offerings or publications. And it's just in that case, it's just hard because you would need to be under the hood. You need to be at Microsoft to tell how that's done. And so it's just, this kind of example is kind of we're kind of stuck. We don't have a good enough case to move forward on that front. And I think, in hindsight, we would have, if we had the chance to write the claims, would have been much more trying to attach to tangible things, trying to attach to things that will be outside the company. So it's just a really kind of a word of the wise about claim drafting. It's just so important to make sure that they're written not just to cover the technology, but with infringement in mind, thinking about potentially enforcing your right down the road. And that's one of the big reasons why, of course, I'm kind of biased, but I advise clients to work with patent attorneys, not just patent agents. An agent is going to get the job done, they're going to get the claims written and prosecuted through the examiner, but they may not be thinking about the way the law is written and how you need to enforce those rights once they get to a place where you're ready to enforce them.
Right. Well, with that said, I want to ask you a question, and I didn't plan on this question, but it's kind of brought me to it. There's a big, misunderstanding about provisional patent applications and putting claims in a provisional patent application. Now, I do know that no one ever examines a provisional patent application per se, but, do you suggest putting claims in a provisional patent application for later on for, kind of maybe developing into for further utility patent? Is that something you?
No, we do just one fairly broad claim. There are a few countries in the European Union that will, look at it real hard if you don't have a claim, and sometimes they'll actually they won't give you the priority benefit. It's still up in the air with a few countries that are an absolute novelty or really want you to have at least one claim at the provisional if you're going to be claiming priority to it. Make it really generic. But no, there's no reason to go through a whole set of claims. It's one of the beauties of the provisional is you can lay out all your alternative embodiments, lay out as broadly as you can your invention. Of course, it has to be enabled, right? It's got to meet the requirements to have the priority, but you're not going to want to lock into specific claims until you're really ready.
Okay.
You can start testing, right? Go start prototyping if you haven't already. Test the darn thing, sell it, right? And see if it takes. And then about 9-month mark, start, really nailing down what it is your invention is and claim it then.
Okay, great. That's great information. Carmine, is there any questions you have that you were thinking at all?
I have so many, but no, it's good because as Jeff and as you guys also know, is one of the biggest fears of all the inventors. I'd say 99% of the inventors that come to me, come to Jeff, and probably to you guys, is the fear of their idea getting stolen. And it's something that you want them to be cautious about, but we don't want them to let it drive them to the point where they don't move their ideas forward.
Correct.
And that's it happens a lot. But there is a lot of, and the reason I love your guys' firm is the way giving out books, giving out information. You're not just trying to land a client. You're trying to educate your clients. And it's a great thing because an educated client that comes to your firm, it's just a lot easier for you to help them, I'm sure. So Irene, real quick question. We have a lot of times clients will come to us with their idea and they'll have a provisional or they'll have a patent in process, but they're still asking us to sign a non-disclosure agreement. It's very tough for us to sign a non-disclosure agreement in the first place because many times simultaneously, as you guys know, inventions are being invented. It happens a lot, and we'll see the same types of inventions many times, but we get to the point where it's hard for us to sign a non-disclosure agreement, but then I find they have a provisional patent or they have an actual patent. I think that they just don't know the process. So is it okay for me to say they don't need an NDA at that point?
And Irene, I'm sorry, I'm doing all the talking. If you want to jump in. On this one, I would just say, and I instruct clients to do that in certain cases. So when a provisional patent application is filed, I will tell them that yes, you are now able to publicize your invention. You can share it with third parties, and you don't need an NDA. I tell them that because it's a barrier to entry. It's a barrier to a lot of conversations. Here, sign this. It's like, whoa, what do you mean? And big companies won't sign them because they don't want to be liable. They hear ideas all the time, but they want to be able to be free in the market.
That's exactly what I coach. That's exactly what I coach.
It's a huge advantage to have your provisional filed, but here's the catch. You can only share and publicize and sell what's been filed. So oftentimes it happens between provisional and non-provisional. You get improvements. You do testing. You're like, oh, I should have put a wing nut and not a Crespo or whatever. And I should be using this type of aluminum amalgam and not this. Finding that improvement, you need to keep under wraps. And you need to either file a subsequent provisional, which you can do, or file your non-provisional sooner. If you don't have money or don't want to wait or don't want to file that soon, that's when you want to supplement with an NDA. If you have an improvement, a change, even after you file the non-provisional, you would want to keep improvements under your hat because you can file continuation applications. So for a lot of reasons, they're helpful, but I think you're right, that a lot of inventors are just ignorant. And so they'll just do it just to be safe or just in case, they'll have you sign it. And it doesn't make sense. It creates some friction and they're just likely uneducated. But if they are sharing additional information and improvements beyond what they filed, then they're smart to do it.
That's a really good piece of information. The improvements part of it, very important, because that's kind of what we do here, is that they'll come to us with an idea, and it happens with Jeff and his crew, is that they'll have that base idea. And, either Jeff's giving them improvements or we are, and we're talking back and forth about it. And, we know there's a gray area there, but no, that's really important because I want to make sure that I'm not trying to make them think that I'm just trying to get their idea from them, and I'm like, listen, we don't sign NDAs, but you can tell me about your idea, but it's really important. I just wanted to kind of touch base with that and let our listeners hear that from your, and from there. But if it's okay, real quick, I wanted to ask Irene a question. JD's hogging all the time, Irene.
All right.
Irene, so an inventor comes to us, and we'll talk to them. It'll be a new idea or something in that sense. Do you feel that there's a certain time or phase that they should put in a provisional or an actual, utility patent or whatever type of patent, is there a certain time that they should do it? Is it in the development phase, is it the prototyping phase, or that they should definitely have it? Or is there just, it could be at any point?
So I'm actually not a patent attorney. So Judy's probably better at answering this question. But if I may, maybe I add a little bit about, when you guys were talking about NDA.
Okay.
And I definitely agree with JD that eventually having an NDA is very important, especially when you have any improvements are made, and then if you have any trade secrets or any confidential information that you want to protect. And I just like to point out really quick, like having an NDA in place is also important because it gives you a cause of action for a breach of contract, in addition to providing you any damages or injunction relief that are as defined in the agreements. So this is something that I'd like to point out really quick. But the second question, I'm not actually really sure how to answer it. JD, can you help?
Sure thing. So, okay, and could you repeat it with something to do, because I kind of tuned out just a little bit when you said whisper, Irene. You said prototypes?
So, and maybe Jeff can add in after under, but what happens is the client will come to us, they can have just an idea, they can have a sketch, a prototype, a sample. In your opinion, do you think that there's a phase or a time that an inventor should be able to kind of roam free, but at a certain point before they move forward, should they have a provisional or definitely put in paperwork for utility before they move any further? Should there be a stopping point before?
Yeah, absolutely. And this is something we've had to build into our process, in our invention disclosure process, as we say, look, we need to say stop inventing. Okay, this is your invention. You agree, we agree, this is your invention. And yes, there's time that it takes to get there. Once you have it documented, that's what we're going to go search on, okay? And yeah, it's sort of this gray, okay, you have an invention because you believe, you can write it and draw it such that it could actually work, right, for its intended purpose. You don't actually have to have a prototype. That's a huge punctuation mark.
I agree with that, 100%.
They think they have to have these huge machines up and running, the software already working. No, not at all. You need to be able to have the schematic, have the words, be able to talk and relate how it would be done. You don't actually have to have it built, right, to have a patent. Granted, let alone apply it. You should apply when you first have it articulated all the way. So what I was getting to is that when you have those novel functions and features identified, that's when you want to do the search and start the process right away. And if the search comes back that you've got novelty and there's no non-obviousness issue, we should file right away.
Yeah, especially to me, if they're planning on moving this product forward and they believe in it, they're going to move forward. So you might as well get it going.
Yeah, right. Absolutely. There's one thing I want to mention that we usually advise on is right away is, especially with software, we touch on differences in copyright protection versus patenting, and that in a lot of cases, things like the code is not patentable, right? You would never want to patent code, the actual JavaScript and HTML. That's very much akin to the words on a book that author's writing, not necessarily the functions, right? You want to protect the functional aspects of the invention. That's what's protected, and so you could potentially keep the code as a trade secret. And so knowing when to hold back and not file a patent on things is really important. For things like methods and processes, like that one.
Like Coca-Cola, absolutely.
Like Coca-Cola, KFC, absolutely.
Right.
I mean, those are things that have gone on well past the 20 years. That's allotted for patent right. So if you think you have something so special that'll have value past 20 years, you want to think about keeping it as a trade secret. And there's a lot of things you need to do to keep it in place. It does vary a little bit state to state, but there's now a federal enforcement mechanism for trade secrets, which is really cool. But it does take some work, and you should seek counsel to make sure you're protecting your trade secrets properly. We can do that at Bold IP. We're happy to do it. A lot of other firms are too.
That's great. I got a question. Let's just say that someone does file a patent, and then there's changes in their design during the actual after it's been the application's been filed. What does an inventor do in that case? What do they do?
An inventor trying to make changes? Come on.
Come on, man.
Yeah. Well, I mean, that's one of those things. I mean, when you file that application, it's the patent attorney's job, I believe, to articulate that darn invention as broadly as you can, and try to think about and foresee any changes down the road, and describe those. You may not necessarily claim them all, but you'll have it as backing so that you could file what's called a continuation application. And you can have a reference back to that non-provisional, even though aspects, D, E, and F aren't necessarily articulated in the description, but A, B, and C are.
Right.
And you bring from that reference and have a new patent. So you can change the design significantly enough to have new novel features that are hopefully, patentable above and beyond your original. Then you should protect those under a separate parallel patent application.
Great. That explains a lot to me. What about you, Carmine? It really should. Hopefully, it's going to help a lot of people out there. I know we're kind of getting close to the end of time here. One question I want to ask: what piece of advice as an attorney do you just give to an inventor starting out? Where do you suggest them starting?
Well, and I love this. Thank you for that question. I mean, I always advise clients to think about their invention, not in terms of, a lot of times they'll come to me and think of, oh gosh, I just want that patent. Just want that piece of paper with a ribbon on it. And then the money will start flowing.
Yep.
And oh my gosh, how wrong that is. And you need to have a business plan to go along with your technology protection.
Very good.
And this is where Irene comes in, and a lot of our team will help put together a business plan. We'll do this a custom, not everyone has the means, right? It takes time, we need to charge for it. But we advise them to even do it on their own. Okay, articulate what it is you want to do, how you're going to monetize this in technology to get it moved forward, whether it's through license or sale, or starting up your own business and excluding everyone else from doing it. It's so important. So important to understand the market, the industry, how you're different from your competitors, all that good stuff, and just know that what your plan is at the end of the day, so we can help structure that and do the things that Irene does for our clients and help them find real companies or individuals that want to buy your technology.
That is excellent advice. I wasn't expecting that answer, honestly, because I write business plans myself, and I always have. And you're right. You need to have a direction on where you want to go, and I think that's the big problem. A lot of inventors, they get excited, they get really, hey, I want this to be on the market. I want to get a patent, but they don't have a plan. And that's excellent advice, and I really appreciate you saying that. So.
Sure thing.
I would say that when you are getting pretty close to where you have a potential buyer or licensee, then you really start to think about the key terms of the licensing terms itself. Certain terms like whether you want to license it as a non-exclusive license or exclusive, the territory of what countries you would like to allow the licensee to be able to use your technology, certain things like that. A lot of the times, people get really excited when they find someone who are interested in licensing or buying their invention. They forgot about all of these key terms that are actually really matter, down the line. You need to put the period of time as well, in terms of how long you want to have the licenses for, who will be responsible for paying for the patent prosecution fee or for the maintenance fee. I mean, those are the things that are very useful, down the road, because it adds up, right? When you have to pay for this patent maintenance fee, after a certain period of time.
That is excellent. That's excellent advice, and you're right. I think there's where the rub comes in, because a lot of inventors, they don't even understand some of the terms you just said, and that's where I come into play to teach them and coach them on exactly those things: exclusives, non-exclusives, minimum guarantees. What are royalties? What are advances? This is all extremely important stuff. And you're right, territories, very important. These are all great things that an inventor should learn to have in their tools as far as getting their product to the market and the business plan that they put into place. This is great stuff. Thank you, Irene, for interjecting that.
Sure thing.
Well, it's been great today, guys. Thank you so much for being a part of the Licensing Jungle, and we'll send recordings out of the show so you guys can share it all you want on your website and do whatever you want with it. And it was really helpful, and hopefully, a lot of the inventors out there listening will learned a lot today. It was a lot of good information. I really appreciate you being a part of it. So.
Fantastic. Yeah, thank you very much, Jeffrey, and thank you very much out there at Licensing Jungle. Appreciate all the listeners. One more plug, just make sure everyone visits the website, boldip.com, if you want to get some information on our firm. That's bold, BOLDIP.com. Feel free to give us a call too, 800-849-1913. Be happy to talk with you.
Great.
Thank you, everyone.
No, thank you. And again, this is Jeffrey Mangus with Product Coach USA. If you want to learn more about the coaching program, you can visit my website, quick plug, at productcoachusa.com. You can also email me with any questions you have at productcoachusa@gmail.com. Love to talk to you about it. So.
All right, guys. Well, thank you so much for participating today. I want all listeners to know that all the show notes, the websites, all the information, everything we talked about will also be available on Inventors Launchpad website. We'll be posting the iTunes and Google Play. So go ahead and listen. Go, if you have to, go out there to the websites, talk to these guys, ask them questions, because again, nobody does anything great on their own. Go ahead out there and get some help. Thanks again, everybody, for being on the show today.
Thanks, guys. Take care.
Thank you.
Bye.